Now, the Morning Majority on 630.
WMAL.
7:07 on the Morning Majority. Mary Catherine Ham, Brian Newman, Brian Wilson, and Joe DiGenova. How's it going, Joe?
It's going great.
Brian and I talked about on Friday this Clemens trial coming to naught in a sort of dramatic fashion.
The abrupt halt.
Yeah.
Exactly. What are your thoughts on the chances that he may get retried, or whether it's worth even going there?
Well, the real question is whether or not Judge Walton, who's the federal judge trying the case, will allow another case to go forward. Roger Clemens requested a mistrial after the prosecutors twice during the case referred to or tried to introduce into evidence things that Judge Walton had previously ruled could not be shown to the jury. The killer, 2 days before the mistrial was declared, prosecutors had mentioned things in their opening statement that the judge had ruled were inadmissible, and he admonished them at that point and told the jury to ignore what the prosecutors had said. Then, the other day, they showed a tape of congressional testimony by Clemens, and in it showed some comments by Elijah Cummings, which quoted hearsay by Andy Pettit's wife. And at that point, the judge, after taking some time to think about it, and after a motion for a mistrial by the defense attorneys, declared a mistrial. The legal issue will be whether or not the government's conduct was so egregious and that it caused the mistrial that the judge is now prohibited from allowing a second trial. This is going to be a very close call because the government misconduct in this case was multiple, and it may very well be that, let's say a judge doesn't like this case to begin with, doesn't like the Roger Clemens case, doesn't think it should have been brought.
Right.
He has a perfect opportunity now to throw this case out. But no matter what, let's say he allows it to go forward, Roger Clemens will have an immediate right of appeal to the D.C. Circuit. And if he refuses to allow it to go forward, the government will have an immediate right of appeal to the D.C. Circuit. So this could go on for several years.
All right. Did you ever figure out how these prosecutors could be so dumb as to do this twice in 2 days?
I must tell you that in any trial preparation where you use technology like a video machine, or this is all done by computer now. It's all digital. None of it's a video machine. This all should have been prepared ahead of time. All the stuff should have been edited out, which is very easy to do. But because they made reference to it in their opening statement, it's obvious that even the pretrial rulings apparently did not have an effect on them. This is really an egregious error, and the trial court may very well decide that this is just too much and not allow it to go any further. This is inexplicable. I mean, this just doesn't happen.
I don't get it. I mean, I'm gonna smell a rat. It's these guys were like seasoned prosecutors, have great track records. They're very well thought of in the business.
How does that happen, Joe?
That's a very good question. And in fact, if the judge decides to hold a hearing on September the 2nd, remember he has set a hearing for September the 2nd. He may take testimony from the prosecutors about how this happened. The judge has an absolute right to do that. He may decide that the mistake was so egregious and has a sense of deliberateness about it rather than inadvertence. He may decide to take testimony, and if that happens, these prosecutors may not be able to try this case even if he allows it to go forward.
All right, there's a lot of talk about the Caylee's law that is making its rounds. I know they're talking specifically in Florida, which would make it a felony for parents and I think all caregivers to report the death of a child within 1 hour and a child's disappearance within 24 hours. Do we need this law? Would it make a difference at all?
No, it would not. I mean, anyone who's bent on killing their child, which Casey Anthony apparently was, is not going to worry about what the law is. This is not going to have an effect. I mean, if they want to really do something constructive, they should pass a law that says if a mother, or a father, who kills a child is convicted on any count in the case, as she was for lying to the police, they can't profit from it. Take all the money and either give it to the victims or to the guardianship of the victim or give it to public charities. That's what they can do. A law that does not allow a criminal convicted of something. If they're acquitted of everything, you can't control their behavior. But if they're convicted of anything, do not allow them to profit from the crime.
There's no law on the books. I guess it's on a state-by-state basis, but there's no law about when you have to report your kid missing. I mean, 30 days for your kid to be missing seems like a long time.
Well, I don't think there's any doubt that the record in the case shows definitely that she was at a minimum guilty of neglecting her child. And how they could not find her guilty of aggravated neglect is beyond me. The few jurors that I have seen on this seem to have been overwhelmed by their role and seem to have overthought to the point of idiocy. That's not a criticism of the jury system. It may very well be a criticism of this particular jury. They didn't like this case. They liked her. They didn't like the prosecutors. The prosecutors overcharged. There are a million reasons why jurors do what they did. These jurors decided that they wanted all doubt removed, which, of course, is against all the instructions that they were given in the case. When you're a juror, you're told you can only acquit for a reasonable doubt. And they tell you that doesn't mean all doubt. It's a doubt for which you can give a reason. These jurors gave a lot of reasons, and I must say, they were convinced as jurors that the government had not met its burden, although they were asking the government to prove things which the law did not require them to prove, like motive.
Joe, there's an offer on the table right now for Casey Anthony to get $1 million if she does an interview.
Right.
One could only assume that there's some book publisher out there that says if you write a book, we'll add another $1 million to that. Mm-hmm. Do you think under the circumstances that that's appropriate? And should we have laws in place that say you can't do that?
Well, I don't think there's anything wrong with it. I mean, whatever the market will bear. She is a free person. She has paid her price to society. She for the lying. She was acquitted of the murder. If somebody wants to pay her $1 million, it might make me sick. I may feel that it's disgusting. But until there's a law passed that says she can't profit from it, which Florida does not have, she can profit from it. It's a stomach-turning series of events, but she's legally free to do it.
Joe, we wanted to ask you about this Rupert Murdoch dust-up.
It's a dust-up, all right. It's actually a dust storm.
Yeah, what are the chances that it hits these shores? It sounds like some Democrats are calling for investigations already. I'm not sure what the impetus for that was. Something about the 9/11 victims and their phones?
Well, you can always count on Dick Durbin to stir up the pot about something political, as he did yesterday. Right. There needs to be a congressional investigation. Oh, boy, just what we need now while we're trying to figure out what to do about the national debt. The issue here is whether or not any U.S. person, and that could be a human being or a corporation, engaged in bribery overseas, which would be bribing the London police, or that was all done by people only in the United Kingdom who are not U.S. persons. They would have to show that the News Corporation U.S. entity somehow was involved in bribing overseas. That probably is not the case. It seems that this is centered in the UK, and there is absolutely no evidence that there was any conduct in the United States. If there was conduct in the United States, or let's say actual payments, transfers of money, or condonation, in other words, condoning what was going on over that after finding out about it, you would have a violation of what's called the Foreign Corrupt Practices Act, which is the famous Frank Church from the 1970s, where Frank got all upset about U.S. companies paying for contracts overseas, just like all the European countries were doing. And we passed this law called the Foreign Corrupt Practices Act. It's a law that has been widely criticized by corporations and lawyers alike for being overly broad, but it could be implicated in this case. So far, there's no evidence that it has been.
I mean, is it even a congressional issue right now? Shouldn't it be a police matter? I mean, shouldn't the New York Police Department or whoever who has jurisdiction where the possible, breach took place? Shouldn't they be investigated first?
The FBI is currently investigating whether or not 9/11 victims had their phones hacked as they were in the United Kingdom. If in fact their phones were hacked, that would be a violation of U.S. law. It's called wiretapping.
Yeah, okay.
And if they entered their voicemails, that's also wiretapping. And that would be subject to federal as well as state criminal investigation. The FBI is looking into that now. I think for Congress to conduct an investigation, most people who are called before it at this point would all take the Fifth Amendment, and there wouldn't be much to investigate.
All right, Joe. Good to talk to you as always. Appreciate your time.
You bet. Okay, guys.
Joe DiGenova, former U.S. Attorney for D.C. and legal expert here with